Hello everyone. Our case study is on Chernobyl, one of the worst nuclear disasters in human history. Chernobyl happened on April 26, 1986, in Chernobyl, Ukraine. In 1986, Ukraine was a part of the Soviet Union. The Soviets believed in the efficiency of nuclear energy, and they had multiple nuclear power plants. The Soviets wanted to conduct a safety test on their nuclear reactors to see if they could withstand an attack from the United States. The test would simulate a power failure. It was during this safety test when Reactor 4 imploded and caused a catastrophic nuclear accident. To correctly analyze the reason for this tragedy, we must start with the design of the reactor. Reactor 4 had over 20 glaring design flaws that were caused by either negligence or incompetence. Before the reactor was put in operation, KGB investigators discovered these design flaws and created a classified document highlighting these issues. This document was given to the Ukrainian authorities as they had the final decision on if the reactor was fit to run. The authorities decided to suppress the document. From this, we get our first ethical dilemma. We will analyze this dilemma using the EGAT analysis technique. In this technique, we identify the ethical dilemmas, generate possible courses of action, analyze the courses of action, and decide which is the most appropriate. The ethical dilemma in this case would be the suppression of the KGB documents by the Ukrainian authorities. This violates section 72.2i of the Ethics Code. The alternative would be to be more transparent with the design flaws and disclose the KGB documents. This would also be the correct decision. If the Ukrainian authorities had been transparent with their design flaws, Chernobyl would have never happened. Now that we covered the issues with the design of the reactor, we will talk about the actual safety tests. Deputy Chief Engineer Dyatlov did not follow nuclear safety test procedures. The safety test was supposed to be ran at a minimum power of 700 megawatts. Dyatlov insisted that they must run the test at a lower power level in order to save cooling water. The on-site engineers disagreed with Dyatlov's decision, but they let Dyatlov have his way. This brings our second ethical dilemma. Once again, we will use EGAT analysis to analyze this situation. Chief Engineer Dyatlov broke sections 72.2a, 72.2b, and 77.6 of the Ethics Code. He was negligent, he failed to make a provision for safeguarding life, and he failed to cooperate with his co-workers. Dyatlov's staff broke section 72.2c of the Ethics Code, as they failed to act to correct or report the situation even though they knew the danger. We know Dyatlov was hell-bent on doing the safety test at a power under the required limit. His staff disagreed with him, and they had many alternative options. They could do nothing and let Dyatlov have his way, they could report the issue to higher management, or they could boycott the test until Dyatlov complies with the regulation. The best decision would be to boycott the test, but instead they let Dyatlov run the test at low power. Because the test was at low power, the reactor became unstable and imploded. Given the information stated in this video, it is safe to say that Dyatlov, his staff, and the Ukrainian authorities all acted unethically. If at least one of the three parties followed proper ethical guidelines, this disaster would have been averted. Now, we must talk about the legal analysis of this case.
This is a case of tort law where there's no contractual relationship between the Ukrainian government and the citizens of Ukraine. Tort law is the compensation of a party that has suffered damage as a result of wrongdoing, either through intentional or non-intentional conduct. Tort law is applicable for cases which address the key principles proven under a balance of probabilities, without the need for a contract. The relevant precedents of this case are Donahue v. Stevenson for the establishment of tort law, and Winnipeg Condos v. Birdman Construction. As the employer of the nuclear power plant engineers, the defendant of this case is the Ukrainian government, and the plaintiffs are the citizens of Ukraine. Operating room engineers on April 26th were entrusted with the duty of care to conduct tests according to official testing procedures. Through failure to conduct the test according to proper procedure, the engineers broke their duty of care, resulting in the explosion of the nuclear power plant, causing citizens of Ukraine to the exposure of up to 5.6 roentgens of radiation. The citizens of Ukraine will have the right to make a claim against the Ukrainian government until April 26, 2001. As for minors and the incapacitated, this will not apply. Regarding liabilities, the government of Ukraine is responsible for the containment of the nuclear facility to prevent further radiation from escaping into the atmosphere. Amongst this, the Ukrainian government is also liable for the following consequential, general, punitive, aggravated, and nominal damages to compensate its citizens. In accordance to the Canadian legal system, a court would find the Ukrainian government guilty of tort and liable to the citizens of Ukraine for all previously mentioned liabilities.